This morning, the Supreme Court handed down a decision that will change the LGBTQ community for years to come.
The case is U.S. versus Scrimetti, and it is about a Tennessee law which bans gender-affirming care for transgender minors. So this includes things like puberty blockers and hormone therapy.
Today, in a 6-3 decision, the Supreme Court upheld the law in Tennessee. This will have wide-reaching implications. Dozens of other states have passed some sort of ban on gender-affirming care.
6 justices, including Chief Justice John Roberts, ruled that a ban like this is legal. Roberts wrote, quote, "Having concluded that it does not violate the law, we leave questions regarding its policy to the people, their elected representatives, and the democratic process."
9 News legal expert Whitney Traylor is joining us now to provide a bit of analysis of this case. Well, let's just start. Can you explain this, from the beginning? Like, how did a majority decide that this is indeed legal?
Right. So this was an issue related to this Tennessee law that said that banned this transgender care for youth. And so essentially what they said, and I think this is really important, was this law looked at treating transgender youth who were disassociating with their gender identity or their gender they were born with. Mm-hmm. So they can still use these different treatments for things like early puberty or other things unrelated to the transgender issue. And so the real issue that the court was looking at was, one, was this law based on sex? Was it based on gender? And if so, what level of scrutiny should be applied? Because in our court system, when a law is passed, the Supreme Court will look at what level, rational basis, intermediate scrutiny, or strict scrutiny, depending on the rights that are at stake. So in other words, if it's a right dealing with fundamental rights or race, it's going to have to be a very high burden. But if it's something related to, say, an economic regulation or something, it's a low basis, a rational basis. And so here, that's what the court did. They applied the lower basis and said, hey, this law just has to be rationally related to a legitimate goal. And what Tennessee was concerned about was that this was having detrimental effects on these youths that it couldn't be reversed. And so they said, we do have this rational basis in passing this law because it's making Tennessee is arguing it's making youth not like the gender they were born with. And so the court upheld this law and said, yes, it was lawful.
So I previously read Justice Roberts' opinion
Yes.
From earlier, and that implied that these decisions should be left to the states.
Yeah.
Do you personally agree? And does that weaken the government? Does that weaken the Supreme Court, in your opinion?
Well, it's an interesting question, and I don't know that it weakens it, but it is definitely a different take because the court, a lot of times, you can look at what's happening right now with the federal government and how you're having this consolidation of power with the executive branch saying, hey, the federal government, we should be able to go in and go into California and send the National Guard and pull all this other power back. So we're currently seeing this struggle between the state and the federal. Now, consistently with the Dobbs decision that overturned Roe, that was also an argument to say, hey, it should go back to the states, and it really did. So now you have a bunch of states outlawing abortion and a bunch of states like Colorado protecting abortion. And that's really what we're talking about here. And Chief Justice Roberts was saying, this should be an issue for the states. But I think that's a little bit inconsistent with some of the other decisions they've made. So you see the courts just justifying, their opinion.
Okay, well, let's talk about the dissenting opinions on this.
Yes.
Then let's start with Sonia Sotomayor. She's an Obama appointee.
Yes.
And she wrote today in this decision, authorities without second thought, untold harm to transgender children and the parents and families who love them. There is no constitutional justification for that result. She goes on to write that the court contorts logic and precedent to justify the ban. So what are your opinions on what she had to say? Very strong opinion there.
That was a very strong opinion, and importantly, I know there's a certain decorum. Usually with a dissent, you say respectfully, I dissent. Here she said, sadly, I dissent, which was actually, sending a strong message. And I think what she was saying was, look, the court didn't do a meaningful review. You just kicked it down the court and you said, well, there's medical opinions that go either way. This isn't a well-settled issue. So the legislature has a right in passing this law. So, but she did point out and I think rightfully so, that the court kind of said, no, this isn't based on sex. This is based on this medication being used for certain illnesses, if you will, or certain, for certain reasons, right? And so she's saying, but within the very law itself, it talks about sex, and it says that the purpose of this law is defined by reference to the patient's sex, and a determining factor is whether the treatment serves the medical purpose of helping the minor live inconsistent with, quote, the minor's sex. And so she's saying the very law itself references sex. And so to make this distinction and to make this ruling on something other than sex is wrong. And I think that's a strong argument that she makes there.
Interesting. And, Whitney, you know more better than anybody that the law, the process of it can be a very long, drawn-out process.
Yes.
So would you say that this decision today settles the debate when it comes to care for transgender children, or do you think this actually is going to, one, set a precedent? We know that there's more than a dozen other states that want to follow suit.
Right.
And do you also think that this makes things more complicated now?
Yes and no. So we have a decision from the Supreme Court, and that is the supreme, law of the land. Whatever the Supreme Court says applies to everyone. But they were very limited in this decision, and they said, look, this applies to this Tennessee law only. So, for example, in 2020, the Supreme Court said the federal anti-discrimination laws in employment apply to the LGBTQ community, so it expanded those rights. The court today said, hey, this doesn't impact that. We're only dealing with the Tennessee law here. So in that regard, it's very specific. However, our common law system is based on, fact-based patterns. So every state that tries to pass a law, or there's going to be litigation about it, and the Supreme Court's going to have to address it again because they didn't really address it here. They just said, hey, this Tennessee law, rational basis test, it's not based on sex, it's lawful, and that's all we're really looking at. So it continues the discussion, it continues the debate. We now have more law in our body of law as it relates to this very new and evolving area, but we're going to see a lot more litigation because of, this is a novel area, and it's a very, and it applies to such a small part of the population. I think it's less than 1% that identify as transgender. So we're going to see a lot more litigation as this unfolds.
We don't have a ton of time left, but I think we have to talk about what this means for Colorado. And I feel like they've been really proactive. They've been, had foresight to see some of this stuff was going to happen when you look at abortion and things like that. Any changes so far to what's happening here?
I don't think there should be any changes for a couple of reasons. One, this ruling was specific to this Tennessee law. But of course, in Colorado, we passed a number of laws giving protection to transgender and LGBTQ. Up until I think the last bill that the legislature passed was in April. So this was just a couple of months ago. So just like the abortion rights and reproductive rights that are being protected here, I think those are as well. This case is relevant. It's the Supreme Court. But I don't think it changes significantly what's happening here in Colorado.
All right. Well, Whitney Traylor, thank you. We appreciate your analysis.